Just to mention to everyone else, we're having a major windstorm over here. So if the video goes out, it's just normal. It happened all morning. But I was still able to stay on in terms of sound. So.
Where are you right now, Konstantia?
Right between Montreal and Ottawa.
Huh.
So apparently you all got the wind last night, and I guess we're getting it today.
Hopefully,
and I'm using my phone just to make sure that I also have cell signal just in case the Wi-Fi disappears. Like if electricity goes out, at least the cell signal is still there. Anyway, we'll see.
Okay.
Okay, so we have 2 minutes, and the person there, Michael, is always there apparently. So if ever there's any whatever, you can just either chat to him or just kind of say Michael, and he's just going to pop up like magic. So if anybody's having technical or any other issues.
Yep, just like that.
There you go. See?
This is in fact the weekend of our annual American and Canadian Forensic Psychiatry Conference. And it was just, I was thinking I would never have been able to attend this and that, but now I'm able to pop in and out of both. It's very exciting.
The upside to this whole thing, right?
Yeah. These unintended positives from living virtually.
Mm-hmm. The bad thing to having to hold the phone is that you have to hold it so close. It just feels like your face is like right there. You can't sort of step back. So is there some way for us to know when people are in? I guess not yet.
There's 18 attendees currently.
Okay.
You can start at 2 o'clock or just a minute after.
Okay, so you let us know when to go ahead?
Yeah, you can begin now, and people will trickle in. It's 2 o'clock now, so just in the just with time being an issue, I would say just start it right away.
Okay, perfect. Okay. Thank you. Hello, everyone, and welcome to the ILA Canada sponsored panel on privacy, big data, and international law in pandemic times. So we're going to discuss this topic today with 4 amazing panelists. We only have 1 hour. So what I'm going to do is quickly introduce the panelists all at once, and then they will have 10 minutes to discuss and give their talk. And we're hoping in that format, we will have some time left over for questions at the end. I would like to remind everyone that this is a CLE accredited course. It's been approved, and therefore there is a code that is in the chat panel where you need to take that code in order to apply for the CLE credit. I will also post it on here every so often so that you'll be able to see it. My name is Konstantia Koutouki. I'm the president of ILA Canada. I'm also a professor at the Faculty of Law at the University of Montreal, or as we like to say, Université de Montreal, and a lead counsel for natural resources at CISDL. Our first panelist is going to be Dr. Teresa Scassa, who is with the Canada Research Chair in Information Law and Policy at the University of Ottawa, Faculty of Law. She is a member of the Canadian Advisory Council on Artificial Intelligence and a senior fellow with CG's former program in international law. She is the editor and author of several books, including Law and Sharing and the Sharing Economy and Interdisciplinary Approaches to Intellectual Property Law, Her research interests include privacy law, data governance, intellectual property law, law and technology, law and artificial intelligence, and smart cities. We are going to then move on to Dr. Maya Prabhu, who is an associate professor with Yale University's Division of Law and Psychiatry. Her primary clinical role is as a consulting forensic psychiatrist, that's a lot to say, for the Connecticut Department of Mental Health, conducting risk evaluations of persons found not guilty by insanity in Connecticut and other complex cases. Prior to returning to medicine full-time, she was a litigation associate with Davis, Polk, and Wardwell in New York, and deputy counsel with the UN Oil for Food investigation. After that, we're going to move on to Vivek Krishnamurthy. Sorry, Vivek, I did that in two. Director of Samuelson-Glushko Canadian Internet Policy and Public Interest Clinic at the University of Ottawa. He's teaching scholarship and clinical legal practice focused on the complex regulatory and human rights related challenges that arise in cyberspace. Previous to this role, Vivek was the assistant director of Harvard Law School's Cyber Law Clinic and counsel in the corporate social responsibility practice at Foley Hoag LLP. And finally, we have Oonagh Fitzgerald, who is a senior fellow with the Human Rights Research and Education Center at the University of Ottawa. Oonagh is an artist and a director at the Canadian branch of International Law Association. She was also the director of the International Law Research Program at CG, where she edited the CG's latest book, Corporate Citizen: New Perspectives on the Globalized Rule of Law, which explores the legal frameworks and standards for conduct for multinational corporations. So without further ado, we're going to start with Teresa, and we're going to move on from there.
Thank you. Thank you very much, Konstantia. I'm just going to share my screen with you and get this slideshow going. If this works. Okay, someone please let me know if you're not seeing my slides. I'm going to be talking about contact tracing apps, and I'm going to be using the Global Pandemic App Watch project that I'm a part of to provide the context for this. And so the Global Pandemic, what I'm going to do is introduce you very briefly to the Global Pandemic App Watch project, or GPAW, and then talk a little bit about issues raised by contact tracing apps, privacy, public health and public trust, and privacy, contact tracing, and big tech. Just give you a quick overview within the 10 minutes. Our project can be found at the URL on this slide, Global Pandemic App Watch project. This is actually a mapping project that's part of a broader research project that's looking at some of the legal and socioethical issues related to contact tracing apps. And what we have on the GPAW site is we're essentially sharing some of the data that we've been collecting since the start of the pandemic. And you'll find there a series of maps and tables with data relating to the global adoption of contact tracing apps. And so some of the questions that we ask on our maps are, and the map that's the background to this slide is the map that looks at what type of app is adopted. And so there are some categories of apps. For example, the Google Apple exposure notification platform is used by a number of jurisdictions. And those are the ones that you'll see in the pale blue color on that map. Other apps are built upon Singapore's Trace Together, which is shown in green on the map. And then there are other apps that are using different platforms. And so one of the things that we're interested in is what kinds of apps are being adopted in different countries around the world. How many are going their own way? How many are using models developed in other countries, or the model developed by Google and Apple? We also have another map that looks at the degree of uptake of these apps, and this has been a big issue with contact tracing apps, how many are actually being adopted and downloaded by citizens to their cell phones. And so we have another map that looks at that degree of uptake across the different jurisdictions where apps have been used. We have another map that looks at whether the downloading and use of the app has been made voluntary or involuntary, whether it's mandatory. On that map, really there's only one state that has made their current app mandatory. The website also has country-specific tables. There's a separate map for adoption of apps in the US because it's being apps are being adopted at this stage at the state level and not at the national level in the United States. And so all of this is part, as I mentioned, of this broader project that explores legal and socio-ethical issues, but we wanted to share some of the underlying data that we had been collecting. There are a number of issues that are raised by contact tracing apps. The background to this slide is the mandatory voluntary slide, and you can see yellow is for countries where the apps are voluntary. There's one little red spot just over the O in movements in the first line of the slide, and that's Qatar, where the app is obligatory. But one of the issues is obviously privacy. And the different privacy issues that are raised by these apps are dependent on what kind of technology has been adopted. For example, apps that use GPS are capable of tracking people's movements through space. Apps that use Bluetooth record contacts. There have been in the past some apps that have combined both GPS and Bluetooth to record movements and contacts, but the majority of apps we find are now moving to predominantly Bluetooth only collection of contacts. Some apps do collect other data for the purpose of analytics by public health authorities or even AI innovation. And so there are some apps that have been have collected a much greater volume and variety of data, although those tend to be in a minority. And so as you can see, those choices feed into the privacy issues that would be raised by the apps. Another set of issues relate to centralized versus decentralized data storage. With centralized data storage, very, very roughly, the data that is collected by the apps is at least at some point in time, perhaps after a positive notification, is shared with, or a positive test for COVID-19 is shared with public health authorities. And so that's the concept of centralized data storage. Public health authorities have access to the data. And that is something that has, for some, has raised privacy flags. Decentralized data storage, as you see with the Google Apple exposure notification system, involves the storage of data about context solely on the user's phone. And so no data is shared with public health authorities. And so again, what model is of data storage is adopted has implications for how privacy issues play out. I've mentioned the voluntary mandatory adoption. Obviously, with mandatory adoption, there would be significant civil liberties concerns if citizens were being asked to mandatorily track their movements or record their contacts. And so most countries have gone with voluntary adoption. Underlying mandatory and voluntary adoption issues are, of course, technology accessibility issues. You can't make this technology mandatory if, in fact, not everybody has the platform on which the technology runs, which currently, in most cases, is a cell phone. And so this has also been a factor. What we are starting to see is that although the majority of states have had voluntary only adoption, there are some indirect adoption requirements that are starting to emerge. For example, the Ontario government has, and this is not really mandatory, but the Ontario government has automatically downloaded the app onto all work phones of public servants in Ontario. It's still up to them whether to upload any positive test information into the phone, so it's not strictly mandatory, but we're also seeing some instances where private sector employers have required employees to have the app as a condition of returning to the workforce. We've also seen some instances where employers have told employees to disable the app if they have it when they're in the work site. And so there's some really interesting issues around adoption and when and who is making the app mandatory or advising against its use. From an ethics point of view, there are a range of different ethical issues that are raised, the availability and accessibility of technology, risks of harm, from the technology. And there's some really interesting potential risks of harm as well, and risks of differential impacts. So a risk of harm might be if the technology is not particularly effective in identifying positive contacts. For example, people may be receiving positive contact notifications that force them to change their behavior, such as stay home from work when they need to work, or go and get tested when it's actually, there's a long delay or period for getting tested and getting results. And that can have differential impacts. False positives have much less impact on people like myself who get to work from home. If I have to stay at home, I can still perform my job, but it might have a much more significant impact on somebody who has to actually go into the workplace. And trust, of course, is another issue that has been that has bedeviled governments. Our own experience in Canada has been that there's been quite a strong public reaction against the app out of concerns, a combination of concerns, many of which are not well-founded because of the technology that's been adopted, but concerns about privacy and concerns about civil liberties as well. So trust in government is a really important issue. Some of the issues also that underlie contact tracing apps and their adoption relate to privacy, public health, and public trust. In most cases, privacy is an interest that's often balanced against other important interests, including public health. And so these apps raise interesting questions about how to strike that balance between privacy and public health. And in fact, apps that collect or have at least some form of centralized storage provide more data to public health authorities that may help them analyze the spread of disease and make decisions than do apps that have completely decentralized storage. And so it's interesting to think about how that balance is struck with contact tracing apps. I've mentioned public trust in government and what role that plays. And I think there are some interesting privacy issues to compare, or it's interesting to compare the privacy response with these apps between manual and digital contact tracing. There are many instances now where people are voluntarily sharing personal data about their movements and about their contacts with manual contact tracers, or with restaurants or bars where they're required to keep lists of people who and contact information of people who visit. And some of those people may have problems with the app, but no problem with providing information in this analog format, even though the analog format can also raise privacy issues. And so that's something that we find interesting as well. And I can see my time is running out, so I will just flag this last issue that I have on the slide, which is privacy, contact tracing, and big tech. The role that has been played by big tech in the context of contact tracing apps is really interesting. The Google Apple exposure notification system has gained considerable traction as the most privacy protective for contact tracing, but many of its terms and conditions have been designed and dictated by big tech in this field. And I think there's some really interesting questions to explore in that context. And the embedding of particular norms or values by big tech may make it more difficult for governments to address public health data needs. And I think I'll stop there because there's plenty of room for, I want to leave time for questions and from my co-panelists, and I can see my time is up. So thank you very much. And I encourage you to visit our site if you're interested in looking at some of this further. Thanks very much.
I am so sorry. We move on to Dr. Prabhu.
So, Maya, you're muted.
Yeah, I think so, Maya.
So sorry. All right. Better?
Yes.
Well,
Thank you.
You missed my heartfelt thanks to the panelists for inviting me to be part of this presentation, and also to all our audience members who are joining us this Saturday afternoon. I am going to be discussing in particular mental health concerns and big data. And perhaps the day when the robot will see you now on the therapist couch won't be too far away. My major points, again, keeping it brief and hoping that we'll expand on any of these in the discussion, is that the use of big data is not new. What is new in mental health research, but probably what is newer is the scale of the information, the granularity of information that's obtained through mental health apps and wearables, and information that has significance that's taken in real time. And now accompanying big data and new forms of analysis, what does that mean for mental health patients and stigma, and what predictions can be made for them? And perhaps one way to think about the impact of COVID is that it has accelerated the use of any number of forms of digital technologies, far beyond perhaps where the mental health profession was prepared to go, and certainly far beyond sort of regulation of many forms of digital mental health software. And I was going to identify some legal and ethical concerns even beyond privacy. So let me just begin by sort of commenting for people who may be less familiar with sort of mental health research and mental health treatment, that the use of big data or trying to look at aggregate data, particularly across populations, is not new. Since the 1970s and 80s, there have been large population studies trying to look at incidences of mental health, trying to make correlations between that and other medical comorbidities, environmental factors, social factors, demographic factors. This was in the 1980s was what we'd call the real birth of psychiatry epidemiology. Most countries have conducted what we call cohort studies, which is following people along particular groups. So particularly Scandinavian countries have done birth cohort studies. Many people who've been in the military will have been part of large mass data collection of them as they followed them through their military career and lifespan. Administrative claims are another source of what we might call big data. So these would be billing claims, for example, in which there's a wealth of information about sort of both symptom onset, age onset, treatment, diagnosis, and that continues to be an incredibly important form of data sourcing in psychiatry. More recently, we've looked at, obviously, psychiatry is very interested in sort of genetic factors and loci of genetic variables in order to try to determine and particularly predict mental illnesses in individuals. And electronic health records have become an increasingly important source of information. Perhaps patients don't always realize the extent to which the data that's being collected them gets aggregated and is used in massive chart reviews, often in multi-center studies. Of course, the goal, the holy grail in psychiatry, is to be able to identify, to be able to have better predictive modeling in order to stave off mental illness, or to identify those who are at risk for developing particularly debilitating psychotic illnesses or neurodegenerative illnesses, and then to develop sort of personalized diagnostic treatment, and also to develop what might be called just-in-time interventions. And if that sounds like a very sort of corporate industrial way of thinking about interventions, you're right. Some of these concepts are very much developed from industry. The challenge, of course, is that brain functioning is so highly complex. It is not merely biological data and presentations and phenotypes that's relevant, but looking at social, cultural, and experiential factors as triggers, as contributors to the development of illness. Some of the challenges of sort of gold standard psychiatric research, randomized controlled trials, is that they're incredibly expensive to do. It's very challenging to enroll people. They're, in the end, even large studies end up involving relatively small number of people. You have challenges of too many things to predict and not enough data points. And the hope is with much vaster amounts of data, you can make predictions from complex nonlinear relationships far beyond the tools that we have. So some forms in which new big data is being used in psychiatry will feel familiar. For example, we have the Enigma sort of consortium, which basically pools data across countries in order to combine neuroimaging with more traditional forms of bioinformation, demographics data, behavioral data. And I think in some ways, I don't think this would be very challenging or surprising to people. They just, it'd be like doing a multi-center study, but now we get to do them globally. But more interesting forms of analysis are developing out of artificial intelligence. One form might be sort of natural language processing. So language is incredibly important in psychiatry, that the tone and form of language can be used to both make diagnosis of mental illness and to identify future forms of illness. So a depressed patient may speak more slowly. A person with emerging mania might speak pressured. A person with an emerging thought disorder, psychosis, will have alterations in speech. So natural language and processing analysis has been shown to be able to predict who might develop psychosis and able to distinguish between suicidal and non-suicidal patients, both of whom, for example, will have huge clinical applications. So forms of big data in mental health are increasingly the use of mental health digital apps. There are over 10, if you go onto an app store, you'll see over 10,000 of digital apps. It's important to know that these are not FDA regulated. They're not considered medical devices. There are very few websites that attempt to do a validation of the efficacy or legitimacy of the forms of that sort of app. So we say there's very little evidence for it. Some of the apps are what we might call wellness or coaching apps. They might direct you to their meditation apps. They might give you, they might have yoga. They might have mindfulness and breathing techniques. Some of the apps are developed, for example, like the PTSD coach might be developed by the VA, and it has some, is designed to help specific populations. Some apps are platforms for therapy with transcripts, which then can become data points. And of course, then the question arises, who gets those data points and what's done with that information? So I point this out because users often, I think of these apps as being about access, but they're also about data. Users in using them provide information about location, voice, keyboard patterns, interactions. You can develop a kind of digital phenotyping about your mental health state that patients might not be aware of or users might be aware of. And we have already seen that mobile phone information has been used in effective ways to identify infectious disease spread. It's unclear how this might be used in the future on a larger scale with regard to mental health. I'll sort of identify that future potential forms of big data for psychiatry are wearables. So medications that track to sensors that you might wear, or neuroscience Fitbits which will deliver stimulations to you when it tracks that you've become anxious. A lot of domestic law actually assists big data collection. For example, the mandating of electronic health records, sort of in the name of sort of efficiency and making sure that there's useful access to information. But the question of how that data gets used continues to be a concern. COVID has accelerated the use of all these forms of what I'm going to call digital psychiatry. So for patients who could not get to see physicians, for physicians who were themselves in quarantine, for individuals who were in quarantine, for individuals in high-risk settings and could not leave, for example, incarcerations, nursing homes, expanded telepsychiatry, video platforms seems, of course, like an opportunity. Many jurisdictions would have to modify all sorts of licensing and billing requirements around it. In some sense, COVID accelerated what could be seen as the positive opportunities from expanding mental health access to different platforms. And there has been an acceleration in private sector crowdsourcing and developer interest in continuing to develop mental health platforms and to develop platforms for individuals who might not have bandwidth and who might not have smartphones. So these seem like positives in terms of expanding access. However, there are some concerns, which I will sort of enumerate here, and we can discuss in more detail later. In some sense, the need to resort to non-in-person engagements are only reinforces who has access to broadband and technology and who doesn't. So while it might seem like an obvious pivot to go from in-person treatment to using video, that assumes that patients have access to video, that patients are in circumstances where they feel comfortable using that video. This obviously doesn't capture individuals, a variety of backgrounds, doesn't capture homeless populations, doesn't capture sort of migrant populations. So in a sense, both healthcare disparities and technology access disparities only become underscored. An ongoing concern, of course, is that the value of using big data analysis and algorithms to drive treatment or interventions only turns on how good the data is. So there are already examples where, say, facial recognition does a poor job of identifying already marginalized groups because the public data that was used to train the machine learning is a very limited pool. Similarly, with voice recognition or trying to identify voice patterns, that will only be particularly effective if we have a large number of people, a diverse number of inputs into that. But we already know that individuals from marginalized backgrounds can be very leery about engaging in studies, participating in studies, even accessing and inputting, so that the basis for the data can be quite limited. I'm quite concerned about how we continue to protect the rights of persons who may be predicted to develop disabling illnesses. And sort of, I think Teresa already laid out the challenges of global governance. I think the major issue will be urgency versus privacy. But I'll stop there and I look forward to the discussion. Thank you so much.
Thank you, Maya. And we move on to Vivek.
Thanks so much, Konstantia, for the introduction, to ILA for inviting me to speak today. So I want to build on what Teresa and Maya presented. So they sort of spoke about the impacts of COVID on, well, use of technology to fight COVID. Maya talked about some of the health implications of COVID in terms of mental health, right, and how it's changed, accelerated certain trends toward digitalization. And I want to talk about what the pandemic has done to society more generally and what that means for the right to privacy. So, you know, even before the pandemic, I think it was pretty common to argue that people needed access to a wide range of technologies to fully participate in modern life, right? The price of living a full life in a modern society involves, you know, having access to a cell phone, having access to broadband internet, you know, all of this technological gear, right? Now, of course, if you're a contrarian, you could opt out to a certain extent. You could certainly use cash. You could show up and line up in government offices to get access to benefits. You could go visit your doctor. You could opt out of, if you're a parent of children, of using online educational platforms. That's impossible now, right? I think what's happened with the pandemic and the associated lockdowns and physical distancing and all the rest of it is that the mandatory nature, I mean, you really do not have a choice, right? It is impossible to live your life and to do certain very basic things in society without access to these technologies. Now, there were access problems, which both Teresa and Maya spoke about in terms of access to technology. But there's another issue, right? Which is that the technologies which we have become incredibly reliant upon are all developed by, for the most part, by private companies. And they are provided to us on commercial terms that we can't negotiate over, that you know, often are pretty exploitative in a number of different ways. My friend Dipayan Ghosh at the Harvard Kennedy School wrote a book, and he calls these contracts terms of disservice, right? So we talk about the economic relationship and why that's unfair, but let's just stick with privacy specifically, right? The foundation of privacy law in most countries is really around the idea of consent, right? So we've all had the experience. You are registering for some online service, whatever it is. You're given this vast, you know, 37-page contract to look over, scroll down, and you click I accept at the end, right? And it is that moment where you are consenting by clicking the I accept button right? That's the consent. And, that's a lot of scholars have certainly been raising troubling questions about the validity of that consent in the pre-COVID era, right? Again, when these are essential services, right? So we can debate how essential something like Facebook is, or how essential something like Uber is, right? But that's sort of the fiction, is that you have some ability to decline the contract, right? And there's like a conscious and willing, acceptance of those terms. Right now, we are all accepting those contracts under something that feels like duress, right? So the obligatory nature of having to accept those things is just increased, right? Which raises, I think, a very fundamental question about the entire basis of privacy law in most countries, right? So, I did a little bit of looking around, and what I think is pretty incredible. So there's not only the contractual element that we are forced to accept certain kinds of agreements to access sites, but there's also the persistence and prevalence of online tracking, right? So in preparation for this, I looked at a bunch of government websites from different governments in Canada and around the world. And incredibly, almost all of them are running private sector trackers, right? So Google Analytics, Facebook pixels, right, to obtain analytics about who's visiting, et cetera. So I think that also raises some really difficult questions about in an era where fundamental government services have to be provided online. How should governments and other entities be structuring their online services to, at least pay some respect to our notions of privacy? So I think we have a real problem in privacy law that's been building for a long time. And, I think it's interesting that the GDPR, which is widely seen as the strongest privacy, data protection law in the world, does sort of move away from this consent basis to recognizing other legitimate bases of data collection, right? And there's this general move in the law towards thinking about that. But, since this is an ILA event, and we're talking about the relevance of international law, I think it's important to point out that we do have some international privacy law, right? We have Article 17 of the ICCPR, for example. Article 12 of the UDHR protects privacy, right? And there are some elaborations of what that means specifically and what the obligations are on states to protect privacy, including in an electronic context. But, we don't yet have much if any, granular data protection law at the international level, although there are some efforts to change that with renegotiating something called the Council of Europe Convention 108, which is a very outdated international legal instrument on data processing to bring it in line a bit with the GDPR. So, prior to the pandemic, there was a lot of conversation about privacy and data protection law reform in many jurisdictions, right? In 2019, we saw a flurry of state-level legislative activity in the U.S. and several bills before Congress to create a national U.S. privacy law. We've had conversations here in Canada about reforming PIPEDA, right, which is our private sector federal privacy law. India has been considering enacting comprehensive data protection legislation. But the pandemic has just sucked all the political oxygen out of the room, right? So the movement on those reform efforts has really stalled. And that's a particularly unfortunate moment for that to happen, precisely because we're all living our lives online, right? We're doing this over Zoom. We're doing this on the affordances of a private video networking operator whose terms I've never read, instead of in person, right? Which is what we would have done if the pandemic had not occurred. So anyhow, I think the bottom line is that clearly it's troubling that we're in this place right now where we have no choice but to accept these terms of disservice that are foisted upon us, right? And that is the reality of the pandemic. I do hope, however, that once the pandemic recedes and once other things are on the political agenda, the experience of having been essentially forced to accept all these terms for the basic essentials of modern life will lead us to reconsider both, the bases of privacy law and the, sort of the mandatory character and how strictly we protect privacy as sort of a mandatory matter of law. All right, I'll leave it at that. Thanks so much.
Thank you. And we are now moving on to Oonagh.
Thank you very much, Konstantia. And it's wonderful to hear the presentations from all the other panelists. Hopefully I can add something. I'll speak a bit more generally about the human rights context, a little bit more on the promise and peril of technology with COVID-19, and discuss international legal, ethical, policy, governance frameworks that could be relevant here. So to start off, I thought it was interesting to note that Freedom House has pointed out that we're now facing some pretty serious issues in relation to democracy and internet freedom around the world. That the COVID-19 pandemic has fueled a crisis for democracy around the world. Since the virus outbreak began, the condition of democracy and human rights has grown worse in 80 countries. And governments have responded by engaging in abuses of power, silencing their critics, and weakening or shuttering important institutions, often undermining the very systems of accountability needed to protect public health. So this is a serious problem. And then if you add to that the issues around global internet freedom, I think we are in quite a crisis. So for the 10th consecutive year, users have experienced an overall deterioration in their rights, and the phenomenon contributing to a broader crisis for democracy worldwide. So internet freedom has really, there's sort of three trends associated with what is happening there. First of all, political leaders have used the pandemic as a pretext to limit access to information or even to spread false news. Second, authorities have cited the pandemic as a justification to expand surveillance powers and the deployment of new technologies that were once seen as too intrusive. And third, we're seeing a sort of splintering of the internet into sort of cyber sovereignty, where each government is imposing its own internet regulation in a manner that restricts the flow of information across national borders. So this is obviously problematic when we also know that we need to share information, especially health information. We need to be able to share information about the pandemic so that as a global community, we can deal with these issues. But it is really important to notice, as we are more and more dependent on technology, we are in fact seeing this kind of shutting down of freedoms around the world. Now, there was a lot of expectation that artificial intelligence and big data can really help us. And Maya and Teresa have given some fantastic examples of why it is really important to be able to use these technologies to help us deal with a global pandemic. One of the challenges, of course, is that for artificial intelligence, we really need to have good data and comparable data of high quality. And that is a challenge when countries face capacity issues in putting together that data. So how will we get good data to share amongst nations? That is definitely a question. The potential application of AI to the management of COVID-19 faces several barriers. The AI needs large amounts of correctly structured information to be trained. And while information is becoming ever easier to obtain, the infrastructure to mine, integrate, and share the data in compliance with all relevant ethical, legal, and regulatory requirements remains lacking. And there are this presents particular issues when we talk about the gathering epidemiological data across broad geographies. So I thought I would mention that we've already made reference to some international law standards that are relevant here. And privacy is definitely protected in international instruments such as the International Covenant on Civil and Political Rights, the European Convention on Human Rights, the American Declaration on Human Rights as well. However, human rights, privacy is often subject to reasonable limits of some kind and even to derogation in times of crisis. So it's really important for civil society and the legal community to continue to apply pressure to ensure that privacy is properly protected as we deal with what is obviously a global crisis. So I wanted to mention that at the UN level, there's been a lot of discussion about how to engender better digital cooperation. And indeed, there's a high-level panel that the Secretary General of the UN has launched, and they have made recommendations that are quite relevant to the pandemic. And it's perhaps a bit ironic, but 2020 was going to be the year of digital cooperation, and here we are living our digital lives. So hopefully we will be enhancing cooperation. The 5 recommendations are as follows from this high-level panel. And I should mention that it's a panel that includes a lot of experts around the world, including private sector expertise. So first of all, they talk about the need for an inclusive digital economy and society. And in fact, they're linking this idea of digital cooperation with the Sustainable Development Goals. So they recommend that by 2030, every adult should have affordable access to digital networks. They also think there should be broad multi-stakeholder alliances to develop ideas about digital public goods, how to engage and pool data sets so that will help achieve the Sustainable Development Goals. And they want to support full digital inclusion and digital equality for women and traditionally marginalized groups, and develop metrics to see how we actually achieving digital inclusiveness. Another recommendation is on human and institutional capacity, that they need to really develop that, and they had an idea of regional and global help desks. The idea of third recommendation was on human rights and human agency, the idea that there needs to be recognition of the human rights dimensions of the digital revolution, and that all UN agencies need to think about how their instruments need to evolve or need to be interpreted in light of the digital revolution that we're seeing. They also recommend that autonomous intelligent systems should be designed in ways that enable their decisions to be explained and humans to be accountable for their use in all circumstances. And that AI systems need to be subject to ethical standards. They also make recommendations on trust, security, and stability, and the importance of that, and developing a global commitment to that. Teresa talked a little bit about that kind of a notion. And then finally, this idea of global digital cooperation, that there should be a consultation process to develop updated mechanisms for global digital cooperation in a multi-stakeholder systems approach. Another guidance that we can look to when we think about a digital revolution and the use of AI in relation to human subjects, as we may be seeing with apps and various technologies being deployed to deal with the pandemic, is the Montreal Declaration for Responsible Artificial Intelligence Development. So the objective of that was to develop an ethical framework for development and deployment of AI, and to guide the digital transformation and transition so everyone benefits from technological revolution. One of the principles really focus on ideas of well-being, respect for autonomy, privacy and intimacy protection, solidarity, democratic participation, equity, diversity and inclusion, prudence, responsibility, and sustainable development. So these are obviously going to be relevant principles. The other, there have been ethical guidelines that have been discussed. In fact, in Teresa's work, you heard about how many countries have been trying to devise ways to do contact tracing, develop apps and use them, such as not to infringe unduly on human rights and privacy. So here's one guidance that that has been developed, and it was published in Nature magazine, and they come up with 16 principles and questions that you ask. So I'll just run through them. First, is it necessary? Is it proportionate? Is it sufficiently effective, timely, popular, and accurate? Is it temporary? Is it voluntary? Does it require consent? Are the data kept private and users' anonymity preserved? Can users erase the data? Is the purpose of data collection defined? Is the purpose limited? Is it used only for prevention? Is it used for compliance? Is it open source? Is it equally available? Is it equally accessible? Is there a decommissioning process? So one of the points that have been made is that a lot of privacy rights are about individuals, but some of the issues we're talking about here when you're gathering data on many people is populations. And there may be some guidance from humanitarian expertise in data protection. So that's one context where people have had to deal with populations in very extreme circumstances and how they protect their privacy. So we could also look to standards that have been developed in that context by the Red Cross and the Red Crescent Society. There's a code that Harvard Humanitarian Initiative on Signal, called the Signal Code, that also looks at how you protect the right to information, the right to protection, and security and privacy, and how you can rectify information if it's incorrect. One of the ideas is that people have a right to their data, and that there is sort of this notion of data sovereignty for different populations, and we need to protect that. So here are just some ideas about standards that are being developed right now to help address these very challenging issues of using technology, big data, and artificial intelligence to help us with the fight against the pandemic. Thank you very much.
Thank you, Oonagh. Thank you, everyone. I know that there was already a question in the Q&A that Maya very kindly answered. So I am...
But not trying to foreclose anyone else's answer.
Of course. I'm just trying to see if there is any other questions that are sort of maybe waiting before we go back to that one. If we can ask the help of Michael for 1 second to just make sure that I am not missing something here. Okay.
Nope, everything, there's just the one question in the question.
Okay, perfect.
I see.
Okay, so
I
we have another question in the Q&A. And it's from an anonymous attendee. How can law students and young lawyers contribute to promoting human rights regarding privacy, big data during the pandemic in international human rights law? Are there any specific areas of research you would suggest for students? Does anybody want to start with that one? Perhaps Teresa?
Yeah, I'm happy to jump in and start. I think there's a tremendous amount to be done. There's so many issues that I think those of us who work in this space are often feel overwhelmed and exhausted by the number of issues there are and how new issues keep coming up all the time. So there's a tremendous amount of space for students to engage in research and activism. In terms of any specific areas of research I'd suggest for the students, I actually think that data science and data literacy skills are becoming increasingly important to being able to do good law and policy work in this area. So I'm finding, and I have been finding throughout my career, that this is becoming a more and more, this is a field where interdisciplinarity is more and more important. And so I would certainly encourage students to, at the same time as they develop their legal skills, that they also develop their data science skills.
Anyone else would like to jump in?
Yeah, I was just going to add that I teach privacy law right now, and my class has an exam option that no one has taken. And the reason is, of the 27 students in there, is that there's so much to write about, right? So you could do everything from, go ahead, analyze that privacy policy, right? Examine the legislative proposal, hold your government to account when they're planning to do something, right? So every day, you pick up the newspaper virtually, and find some kind of privacy issue that no one's examined before in any serious way and write about it, right? So advocacy is great, of course, but there's a lot of analysis that students can do that can sort of advance our knowledge and improve the state of privacy by sort of bringing that up on the public agenda.
I just would like to add a comment on this. I think there are so many human rights issues to think about now. And just from a bit of experience from 20 years ago when we had 9/11 and there was this huge crisis in the world and a massive response by governments and then by technology companies to support governments in various efforts to combat terrorism. Well, we ended up, even though there were sometimes sunset clauses built into legislation, we ended up with an anti-terrorism regime that we're still living with. And we have to be really aware that whatever we do today to fight the pandemic, we need to be able to assess it, review it, sunset it, and learn lessons from it, rather than just sort of accepting that we're moving into a new world where everything is subject to surveillance. It's really important for us to be conscious of the fact that we need to watch the space.
Okay, so I'm just gonna, until another question comes in, I'm just gonna throw a question out there. Are corporations that provide online platforms or deal in big data and healthcare data gaining unprecedented advantages from the COVID-19 pandemic that have privacy and human rights implications? If so, what, if anything, is being done on this? And this is one of the questions that the panel thought would be interesting to sort of discuss online. So we can go in the same order, unless Maya, you would like to start this one since you didn't jump in on the last one.
Yeah, well, let me start by answering the last one a little bit, because I think it segues to this, which is I wanted to reinforce what was said about the importance of interdisciplinary work. So much of sort of human subject research guidelines, data research guidelines, privacy guidelines is sort of reactive as opposed to proactive. This sort of, you think about the Nuremberg Code was a response to the Nazi medical trials. In the US, you think about the federal Belmont report and what we call the common rule, which are, if you get federal funding, you're subject to particular data privacy obligations. Also a response to the sort of the Tuskegee syphilis trials. And so I think the reason why the law is always behind the development is because we don't have people who understand both in real time. And when there is a pandemic and a sense of urgency, you just want to throw whatever resources are necessary to solve the health problem and then try to play catch up. I think this question of being able to anticipate how data is going to get used, which means really understanding the technology, is the only way to develop flexible, foresightful regulations. And the truth is that there's very few people who can speak both languages fluently.
Would anyone else want to jump into either continuing the first question or the second?
I was just going to make a comment, a slightly optimistic comment with respect to your question, Konstantia, about the potential of corporations either gaining huge advantages and because of COVID, et cetera. Well, we know that they are, that's for sure, right? I mean, we know if you look at the stock market, we hear about Amazon, et cetera. Clearly, the digital platforms and companies are doing very well. The only positive aspect where there was sort of a place for government and civil society and academia to get involved is that the fact that they are working with governments to try and work out these solutions to problems such as contact tracing, data collection on pandemic issues, et cetera, it maybe provides an opportunity to increase their sensitivity and about the importance of protecting privacy and protecting the individual's rights to autonomy and agency in relation to their data. So in a sense, it's an interesting inroad. for that discussion, but it's not going to be an easy discussion.
Okay, we have another Q&A that's from the audience, and I'd like to sort of privilege those questions for a moment because we only have 4 minutes left. So I'll read the question and you guys can jump in as you like. On the note of privatized companies and big data, high-profile cases within privacy breaches on a huge level involve serious penalties to users. Should hackers or coalitions of hackers be treated as international non-state actors for purposes of enforcement, or should this be handled only at a member state level? It's an interesting question. So how do we deal with a coalition of hackers or an individual hackers that are able to sort of access this information in ways that may not be what a user has signed up for?
I can take a crack at that, which is that, I think if we characterize them as international non-state actors, right, what additional tools do we have to deal with them? And the answer is probably not that many, right? So, for example, just this week, we saw the United States indict a number of Russian GRU officers who are obviously state actors who've engaged in hacking in the United States, right? And they were sort of indicted in their individual capacity, right? So that's sort of the legal mechanism of recourse. What's more interesting is that there's a sort of big debate in the cybersecurity literature around what's called hacking back, right? The idea of taking unilateral action against hackers who are causing damage to systems, either by governments or by private corporations, right? And this is sort of a very controversial area of the law in the US and elsewhere as to how much sort of self-help should the victims of offensive hacking be able to engage in to go disable those kinds of networks wherever the world they might physically be located.
Okay. Does anybody else have anything they would like to add? Or perhaps even entertain the idea that that in certain cases, what we would deem sort of hackers is not necessarily in the negative. So it's, is someone a whistleblower or are they a hacker? So in that, sort of context, how does the law kind of, are we in the law is the law kind of situation, or do we sort of say, well, this particular hacking has led to something beneficial, therefore we treat it one way, or this particular hacking is, because I do think it's a very interesting question when we're talking about privacy and big data, because that's sort of the elephant in the room, right? If someone is able to bypass all these legally enforced means of ensuring privacy, then, what are we talking about?
So, there is a distinction, right, between security research, right, which is saying, so you test the defenses of a system and sometimes you get in and then you disclose that, right? So there are ethics around, and I'm going to use these terms advisedly, so-called white hat versus black hat hackers, terrible terms that I hope are replaced in view of sort of the racial connotations around them, right? So I think there are questions of intent, motivation, and then if information is taken, so we could have that debate about WikiLeaks, right? They obtained information by breaching computer systems or pursuant to breaches, and then they publish them. And there are questions of who should be liable and when that occurs, right?
Well, unfortunately, we are at 3 o'clock and it just goes by so fast. Oh my goodness. So I would like to thank everyone, our panelists and ILA US for inviting us. And everyone in the audience. This was a great discussion. And as you may know, all the contact information about all of us is freely available all through the internet. So if you have any further questions, you need to get contact with us, or there's something that someone had said that you would like to further discuss with them, feel free to do so. Of course, I'm speaking for everyone, but thank you very much and have a nice day.
Thank you.